Hello, everyone, and welcome to Uncivil Law. And for today's story, we have a case that took 4 times to get it right. We turn our attention to this New Jersey case of a wife and husband who were convicted of various horrendous child endangerment crimes. And for some reason, the trial court didn't want to punish them very much. And the Court of Appeals it took 4 times to get it right. They sent it back over and over and over again because the court refused to punish them enough. It's like the sentence is insufficient, try again. The sentence is insufficient, try again. 4 times it took. So we're going to discuss this story just because I thought it was interesting procedurally. We turn our attention to the Court of Appeals for the Third Circuit in the case of United States of America versus Carolyn Jackson and John Jackson on appeal from the District Court of District of New Jersey. And this is what the Court of Appeals writes in this precedential decision. Carolyn Jackson and her husband, John Jackson, were convicted of horrific child abuse after a 39-day jury trial. They're not nice people. The original trial judge sentenced the Jacksons 3 times. 3 times. The judge is like, how about this sentence? Court of Appeals is like, no, try again. How about this sentence? No, try again. How about this sentence? How about a different judge? Maybe that will be the clue. The Jackson sentences each time, of course, were vacated, and on the third appeal, were resentenced to a different judge for instructions, try actually following what we said. The Jacksons now bring this appeal challenging their sentence imposed by the new judge, but no, we're happy now. We feel like you actually gave them enough time this time around. So no, we're happy with the sentence that is not sufficient. All right, because the facts, of course, have been reviewed at length, we're not going to discuss them. Sufficient to say this case involves serious child abuse inflicted by the Jacksons on 3 adopted children, Joshua, C, and J, all below the age of 4. Great. We've got 3 adopted children below the age of 4, and we're abusing them. That's super exciting. The Jacksons were charged in a 15-count superseding indictment with conspiracy and several counts of endangering the welfare of a child. At a jury trial overseen by Judge Catherine Hayden, John was found guilty and Carolyn was found guilty. Some of the counts, termed the omission charges, charged the Jacksons with withholding food, water, and medical care. The other counts, known as commission counts, charged the Jacksons with forcing their children to ingest substances such as hot sauce and red pepper flakes and physically assaulting them with various objects. These people have problems. All right, while Jackson 3 was pending, that would be the third appeal, Carolyn Jackson completed serving her most recently imposed sentence. Lol. All right. Oh, and incidentally, by the way, although there were state law violations, the Jacks were charged federally because these offenses occurred on a military installation. And the New Jersey law was accordingly assimilated into federal law pursuant to Assimilative Crimes Act. So in case you're wondering why this was a federal case, it's because it happened on a military base. And they were charged on state level offenses, but in a federal court, which the relevant law allows for. So these are state level offenses, but we're charging them in federal court because military base. And so, yeah, so that's what's happening just procedurally. Anyways, in Jackson 3, that would be the third attempt to get this right, we vacated the sentence and remanded for resentencing. The case was reassigned to Judge Susan Wigton, who ordered the pre-sentencing reports be prepared. After consideration of the entire trial record, the pre-sentencing report, sentencing submission, and parties' presentation, this judge sentenced Carolyn Jackson to a term of 140 months and John Jackson to a term of 108 months. So 140 months and 108 months for the multiple counts of the child endangerment for the under the 4-year-olds. That was the high sentence. That was the high sentence. The district court had jurisdiction under relevant law. We have jurisdiction under relevant law. We review findings of fact for clear error. We review questions of law, including whether the law of the case doctrine applies de novo. We review procedural and substantive. We review the procedural and substantive reasonableness of a sentence for abuse of discretion. So sentencing is abuse of discretion analysis, and apparently it was so bad, we tried 3 times. However, when a party did not object to alleged error at sentencing, we review only for plain error. So if there is no objection, then plain error instead of abuse of discretion. All right, so here is a little bit of the findings. John and Carolyn Jackson raised the following issues on appeal. They argue that the new judge violated their Fifth and Sixth Amendment rights when she found facts at sentencing by preponderance of evidence, violated their Fifth and Sixth Amendment rights by resentencing them after they finished serving their previously imposed sentence, violated the law of the case doctrine, imposed procedurally unreasonable sentences, and imposed substantively unreasonable sentences. We affirm. Go away. Please suffer. We hate you. Facts pursuant to sentencing need to be only submitted to a jury when such facts raise the applicable statutory maximum or minimum. So we don't need to provide facts unless it changes the statutory range. If it's a statutory factor, then it needs to be submitted to a jury. Otherwise, the judge will be fine as far as the federal law is concerned. The Jacksons argue nonetheless that their Sixth Amendment right to trial by jury and Fifth Amendment right to due process were violated when the district court found, by preponderance of the evidence, that Jackson's offenses caused serious bodily injury or involved a dangerous weapon. These factual findings supported the district court's application of aggravated assault guidelines and resulted in higher application of these sentences. The Jacksons argued district court's application of the aggravated assault guideline made them liable for committing aggravated assault, a crime for which the jury did not convict them. No. If we were charging you with that offense, then yes, but it's a sentencing factor in this fine. So no. Anyways, they also argue the statutory maximum for purposes of the maximum sentence may impose solely based on the facts reflected by a jury verdict. Therefore, they contend the Sixth Amendment and due process clause requires these facts to have been found by a jury. We have repeatedly rejected these arguments and held that judicial findings of fact that increase the guidelines range, but not the statutory maximum, do not violate the Constitution. No. Here, the district court sentenced both Jacksons to a term of imprisonment within the statutory maximum term of years of 10 years, and the court's findings of fact do not increase the range. Consistent with her precedent, we conclude the district court did not violate their things. Yeah, and just incidentally, because I don't know whether or not the court is going to discuss it at some point, but just let me give you the what happened in terms of sentencing. All right, so the first time around with the original district judge at the first sentencing when they were convicted, in 2015, the district court imposed 24 months imprisonment for the wife and probation for the husband. Wow. I mean, that's a generous court, right? How about 24 months for the wife and probation for the guy for the horrific child abuse? Wow. The Court of Appeals is like, we don't think that's enough. Maybe a little bit more. All right, so then we went back to the district court, 2018. All right, how about 40 months imprisonment for the wife, but still probation for the husband? Court of Appeals, no, not so much. We had other exciting numbers in mind. 2021, the district court, fine, 40 months imprisonment for the wife and 18 months home confinement for the husband. No. Also, we want a different judge. We've tried 3 times with you. And then we finally wound up at 140 months for the wife and 108 months for the husband. And the Third Circuit says, okay, good enough. But the initial sentence was 24 and 0. The Court of Appeals didn't think that was good enough. So yeah, good times. All right, anyways, let's talk about finality of sentence. The double jeopardy clause of the Fifth Amendment provides that no person shall be subject to the same offense to be twice put in jeopardy of life or limb. In sentencing context, double jeopardy right attaches when a defendant has a reasonable expectation of finality in the sentence. A defendant whose sentence is under appeal has no expectation of finality until the appeal is concluded or the time for the appeal is expired, which, fair enough, right? I mean, that's normally what makes it final when you've sort of exhausted your appeals. Yeah. Only the defendant can appeal. No, that the government can appeal for insufficiency too on the sentence. We're not convicting them. or not, right? It isn't not guilty. It's guilty, but here's the sentence. And the Court of Appeals is like, and the government's like, this is widely insufficient. And the Court of Appeals is like, you're right, because it's a pure issue of law, right? It's just pure law. It's like you've already been found guilty by the jury. There's no findings of fact. It's pure law. It's just legally insufficient. So yeah, the government can appeal insufficiency of a verdict or apologize insufficiency of a sentence. It's hard. It almost never happens, but this Court of Appeals thought, a little bit more would be needed. So, yeah, the government can appeal insufficiency of sentence. Therefore, no double jeopardy clause is implicated where a defendant is resentenced after the sentence was vacated on appeal. Says no, try again. Lawful resentencing after vacator does not put you in twice jeopardy because the sentence is, as corrected, imposes a valid punishment for the offense instead of an invalid. You're not being punished twice. You're not being punished twice. We're just trying to figure out what the right punishment is. All right? So original punishment vacated. Let's give it another go. We still want to only punish you once, but we want to get the punishment right. The Jacksons argue, though, once a defendant completes a sentence originally imposed, though under appeal, he has a legitimate expectation of finality. That's dumb and doesn't make any sense. Like the district court, we recognize this is a matter of first impression. The Supreme Court's seminal decision in D. Francisco did not address the application of double jeopardy principles to a defendant whose sentence has already been served. Our court's decision in United States versus McMillan awful less open the possibility a defendant who completed satisfactorily his sentence may have a reasonable expectation of finality as to the completed sentence. Today's decision forecloses it. So they're like, yeah, we've never actually decided this question before in our circuit. We've never decided. We sort of implied before that maybe, but now we're saying no, not so much. Because obviously that's dumb, right? If the district court says, how about 0? And then my sentence is just over because I've already finished it, or like 1 month, something de minimis, and it's just over, there would be no ability to redress it. And that's kind of stupid. Right? So it's like, yeah, you still get credit for your time. So don't worry, you do get credit for time served. So the time you served will absolutely count towards your new exciting sentence, but no, not so much, no. To support their arguments, the Jacksons cite cases that either misconstrue or rarely distinguishable from their situation. For instance, some cases confirm that a district court judge can impose a new sentence without violating double jeopardy clause. Other cited cases are an opposite because they explain a defendant completed sentence on 2 counts cannot be adjusted after conviction on a 3rd count was reversed, which, makes sense, right? So if we're only reversing as to one of the counts, then that count then would have to be resentenced, but the other counts would be final, right? Because there was an appeal, and the Court of Appeals in that situation said, no, we're happy with the sentence on counts 1 and 2, but we're not so happy with 3. And then the district court said, well, I'm going to resentence them for 1 and 2 too. It's like, no, you can't do that, right? Because you already made the decision, we affirmed it, and now that's final, right? You can't reopen that. So, resentence them on 3, but not 1 and 2. That makes perfect logical sense. Okay. Or a prior sentence cannot be amended after the time for appeal has passed, which also, this is not that situation, right? So if the appeal time is exhausted, and then the court was like, well, I'm exhausting. It's like, no, it was final because the appeal time is exhausted. Or the government never appealed. Also, no. So none of those things. Those don't apply. In many of these cases, a legitimate expectation of finality requires the time for appeals passed or the appeal is complete, even where the defendant has served the sentence. Facts. Despite the vast number of cases the Jacksons cite, all support the proposition that the defendant has no legitimate expectation of finality in their sentence while that sentence is under appeal. We decline to break from the precedent. To do otherwise would allow the Jacksons, and incidentally anyone else, to avoid legal sentences and provide them with an unjustified windfall simply because they received such an erroneous short sentence because the district judge is a dum-dum. Because Jackson's sentences were under appeal, they had no reasonable expectation of finality in their sentence, complete or not, and double jeopardy did not attach. The Jacksons also argue that even if their resentencings did not violate double jeopardy, their general Fifth Amendment due process rights were violated because they had a reasonable expectation of finality upon completion of their sentence while the third appeal was pending. Quoting from United States versus Davis, they argue that a defendant's due process rights may be violated where a sentence is enhanced after the defendant has served so much of a sentence that his expectations as to finality have crystallized, citing a Third Circuit case. But Davis clarified the defendant does not automatically acquire a vested interest in a shorter but incorrect sentence. So it's possible, but not necessarily true in every case. Davis does not also apply here because it addresses the defendant's legitimate expectation of finality in a sentence where a habeas proceeding is pending and has no impact on DeFranco's holding the defendant has no reasonable expectation of finality in a sentence until the time has passed. No. The Jacksons argue two other reasons their resentencing were fundamentally unfair and violated due process. First, they rely upon cases that are easily distinguished and not support concluding due process violations occurred here. Second, the Jacksons argue the fragmented manner in which they've been sentenced means due process would have been violated if they were resentenced. What? We have now made clear, however, there's no reasonable expectation of finality while an appeal is pending. We declined to impose a different rule when serial appeals were involved. So, no, there's no finality if the appeal is ongoing, and that doesn't change even if we appealed and then sent it back, and we appealed and sent it back, and we appealed and sent it back, right? It's still under appeal. It's basically one long thing. It's basically one big ass long appeal, I guess, if you want to phrase it that way. But either way, no, just because we did it in parts, no, not so much. While the fragmented nature of the proceedings here is undesirable, it does not violate due process and certainly does not weigh in favor of rewarding the Jacksons with windfall of serving sentences this court has found to be erroneous. The Court of Appeals really hates these people. They really, really hate the Jacksons. They must be really pissed by this fact pattern. They're really pissed. Well, either that or they're just really pissed at the lower court. So it's kind of hard to tell who they're pissed at this point. Are they pissed at the Jacksons? They're probably pissed at the Jacksons initially, but now they're probably equally pissed at the lower court below because we're we're on try number 4. Took a couple times to get it right. The law of the case. The law of the case is a prudential rule that holds that a rule of law announced in a case should apply to the same issues in a subsequent case of litigation. Law of the case may counsel against, but does not prevent a district court from reconsidering prior rulings. Yeah, so when there is a rule of law announced, that rule of law permeates the case. But district courts, of course, are always free to revisit their decisions based on different legal arguments. They're always free to reverse themselves. Right? So if the Court of Appeals announces a rule, that rule permeates the case. But if the district court announces a rule, the district court can reconsider based on other information. District courts make mistakes and they can fix their mistakes. So the law of the case does not apply to you, not in this fact pattern, no. Carolyn Jackson argues that 3 of Judge Wingington's sentence decisions impermissibly contradicted Judge Hayer's earlier law of the case decisions. The law of the case doctrine does not apply here. We vacated the October 15th, 2021 order and remanded. When a sentence is vacated, defendant is rendered unsentenced. Yeah, it was nullified. It was vacated. It's like, what about vacate do you not understand? The law of the case, like what case, kind of? It's been vacated, right? When you threw it out. Try again. Judge Wingington therefore had a clean slate on which there was no law of the case for sentencing. This applies equally to the dangerous weapon enhancement, even in light of the court's Jackson 2 ruling that Judge Hayden had not clearly erred when finding various objects were not dangerous weapons. So yeah, this just shows how much the Court of Appeals hates you. So one of the judges had said, okay, it is not a dangerous weapon. And then a different judge said it is a dangerous weapon. And the Court of Appeals is like, oh, well, too bad, right? So you had a judge who said, okay, I don't find it to be this. And this judge is like, I do. But it was vacated. So they were allowed to reconsider. They were allowed to reconsider all the things. We go back to square one and we try again. And so the new judge is like, oh, I find it to be a dangerous weapon. That's not fair. The other judge says it wasn't. Yeah, but that was vacated. So doesn't exist anymore. But thank you anyway. That ruling neither concluded that Judge Hayden's finding was affirmatively correct, nor bound the resentencing court to find the same. Yeah, we're just like, yeah, that sounds, it wasn't an abuse of discretion, but it also wasn't an abuse of discretion the other way. Oh, well, so sad. As to procedural and substantive unreasonableness, district courts follow a three-step process to sentence the defendant. At step one, the court calculates applicable guidelines range, which includes application of sentencing enhancements. At step two, the court considers any motions for departure, and if granted, states how the departure affects the guidelines. At step three, the court considers the recommended guidelines range together with statutory factors and determines the appropriate sentence, which may vary upward or downward from the range. The Jacksons argue their sentences were procedurally and substantively unreasonable. As noted above, we review procedural and substantive reasonableness under abuse of discretion, which is really hard. Right? It's really, really hard to mess that up, but apparently one judge did it 3 times. When a party appeals an error to which they did not object, only for plain error. When a defendant alleges procedural error, we must ensure the district court did not fail to calculate or miscalculate the range, treat the guidelines as mandatory, gloss over the factors, choose a sentence based on clearly erroneous fact, or inadequately explain the sentence. Carolyn did not object to alleged errors at sentencing, so we review only for plain errors. Plain error. Carolyn urges us to find the sentencing judge abused discretion by relying on inaccurate information, preventing the judge from giving rational and meaningful consideration to the factors. Specifically, she argues the sentencing court failed to recognize that Carolyn expressed remorse, used corporal punishment to punish all of her children. By the way, once again, they're under 4. And the hot sauce and stuff might seem like a little bit much, and the red pepper flakes might be a little bit much. It's like, okay, okay, yeah. And C and Joshua had injuries the defendant did not cause. She further argues sentencing court erroneously blamed Carolyn for Joshua's death, calling the corporal punishment torture, and did not consider Carolyn's positive post-sentence conduct. That's exciting. It's okay I tortured my children. I've been good since then. That's nice. We cannot conclude the district court plainly erred. First, Judge Wingington did not recognize Carolyn's expression of remorse and found it a marginal acceptance of responsibility. Yeah, I don't believe you. I don't believe you. I'm sorry. I'm sorry. Yeah, I don't believe you. I think you're lying. I don't find you credible. Yeah, that's something a judge definitely can do. She was not required to agree with Judge Hayden's finding that Carolyn Jackson fully accepted responsibility. So yeah, again, one judge is like, oh, she's fully accepted her responsibility. But the other judge is like, no, she's a liar. Different judges, man, different judges. And it's been vacated every time. So it gets to be reassessed every single time, man. It's exciting and fun. Exciting and fun. Finally, okay. Furthermore, Judge Wenton said she did not pose a sentence as a means to punish the Jacksons for Joshua's death, did not depart upward based on her view that the children suffered torture, and explained why she found the children's various injuries were caused by the abuse. Finally, there is no basis to conclude that when Judge Wennington stated she hopes Carolyn will do things differently, she didn't consider the post-sentence conduct. Those statements remain in the context of analyzing the factors and recognizing lifelong harm inflicted on children. We perceive no plain error. No. Judge John Jackson argues that Judge Wennington's application of assault guidelines to the omission counts were procedural error. We need not decide where the district court erred because to the extent there was any error, such error was harmless. Holy shit. The Court of Appeals really hates somebody, man. Damn. I'm not saying they're wrong. I'm saying that the contempt is flowing off the page. Shit. Yeah, it's like, okay, yeah, whether or not they did, we just cannot be bothered to care. Maybe the judge made a mistake. We can't be bothered to care. Woof. Woof. Procedural errors at sentencing, which include miscalculation of the guidelines, are subject to harmless error review. In the context of guidelines calculation error, harmless error means the record must demonstrate there's a high probability the sentencing judge would have imposed the same range under the correct guidelines range. That is, the guidelines range did not affect the sentencing actually imposed. The sentencing judge can demonstrate the requisite high probability by explicitly stating she would have imposed the same sentence even under the correct guidelines. However, even explicit statement the same sentencing would be imposed under a different guidelines range is insufficient if the alternative sentence is not also the product of the entire process. John Jackson argues any error was not harmless because the district court only made a general statement that would impose the same sentence without revealing any consideration of the omission counts as untethered to the guidelines. He argues essentially that if the district court had declined to apply the assault guidelines to the omission counts, it would have found there were no applicable guidelines section, and the appropriate sentence for those counts would have been determined solely by factors. Thus, the argument goes that although Judge Winnington addressed the section factors, the alleged error is not harmless because she did not explicitly state the analysis applied. We disagree. We conclude the district court issued a valid alternative sentence that was the product of the three-step sentencing process. The district court explained she accepted the argument of defense counsel, that is, the guideline range of 70 to 80 months, predicated on the conclusion there was no guideline section applicable to the omission counts. She then explained she would vary upwards. So 70 to 80 months was the guideline range, but she's like, how about 108 months? 70 to 80 isn't doing it for me. How about 108 months? She then explained she would vary upwards to reach the sentence of 108 months based on facts, history, and circumstances of the charged offense. Those facts and history were already greatly detailed in her consideration of the factors. The fact the guidelines range is 70 to 80 months, I think, goes a pretty long way to showing why the district court or why the Court of Appeals was not really necessarily happy with how about 24 months and how about 0. Right? Because it's not like the guidelines changed. They couldn't possibly change. The offense didn't change. Right? The guideline range couldn't have possibly have changed. The guideline range is determined by like how bad this offense is and how bad you've been in the past. And as to how bad this offense is, that's done on a calculation. It's done on a score. It's not arbitrary. So the guidelines range didn't change, right? So the guidelines were always 70, 80 months. And so it goes a long way to show why the Court of Appeals was like, oh, because 24 and 0 seems to be quite a bit less than 70. 40 and 0 seems to be quite a bit less than 70. 40 and how about 18 months home confinement, still a lot less than 70. So yeah. I'll fix the title later. Thank you. Where were we? All right. Having expressly referenced them, the district court did not need to restate the analysis. So the original jury that convicted them decide their sentence? No. Sentencing is done by the judge in the federal system. The judge did it. The judge did it 3 times. And then we gave a new judge, and now we're on to sentencing number 4. Those factors and history are already greatly detailed in consideration of the factors. Having expressly referenced them, the district court need not restate the analysis. In sum, the district court process satisfies us. There's a high probability the judge would have imposed the same sentence in the guidelines range. Any procedural error is harmless. Carolyn and John Jackson also argue their sentences are substantively unreasonable. Defendants bear a heavy burden to show that the sentence within the applicable guidelines range is substantively unreasonable. If sentence is procedurally sound, we assume it's reasonable and affirm unless we believe no reasonable court would have imposed the sentence for reasons provided. As long as the sentence falls within the broad range of possible sentences that can be considered, we affirm. John Jackson argues his sentence is substantively unreasonable because Judge Wingington did not adequately consider John's history of abuse and military service as a mitigating factor. Oh, that's nice. I'm glad you served in the military. And that means it makes it more okay for you to abuse your children, I guess. That's definitely okay. The Court of Appeal can ask the judge to be changed? Yes. Is it only in federal court? No. But it is unusual. It is unusual. And as we noted, we reversed it twice. We reversed it twice and gave it to the same judge on the hope the judge would give it right. So it was only after the judge failed 3 times, the original and after 2 appeals, that we said, maybe a different judge. So no, the state systems can do it too. It's just not usually the first thing they do. Usually it's not even necessarily the second thing they do. But eventually they do get pissed off and they're like, we'll try someone else. However, a district court's failure to give mitigating factors the weight a defendant contends they deserve does not make it unreasonable. Carolyn and John Jackson's sentence are substantively unreasonable. The record as a whole, or substantively reasonable. The record as a whole reflects rational and meaningful considerations. We cannot conclude no reasonable court would have imposed the sentence. For reasons prevented, we affirm. So yeah, please enjoy your 108 and 140 and 108 months respectively. Please enjoy your 100. And I know you already served some time. But don't worry, you do get credit for time served. And I know you were released from prison and all, but back to prison you go as we complete your sentence, all the rest of it. Yeah, if someone gets 10 days, can they resentence them to 100 days? Well, possibly if the 10 days is wholly unreasonable, right? It's not that simple, right? So it basically boils down to an abuse of discretion analysis, right? It's basically what it boils down to fundamentally. And so basically the Court of Appeals is like, this was so outside the bounds of what any reasonable judge would do that no reasonable judge would do this. Try again, right? So could you do that for like a 10-day sentence versus a 100-day? I mean, hypothetically, sure. I mean, obviously it's a lot harder to slice that difference, right? If you're saying that 10 days is wholly unreasonable, but 100 days is reasonable, the difference between 10 days and 100 days is not exactly as wide as, 24 months to 70 months. That's a lot more, or 0 to 70 months. That's a lot more span. So is it hypothetically possible that a 10-day sentence could be completely unreasonable, but an 11-day sentence is reasonable? I mean, hypothetically, I suppose, but the courts don't slice it that thin. We're not trying to slice it that thin. We're looking for like manifestly wrong, clearly erroneous, abuse of discretion, wildly cuckoo batshit nuts is the kind of thing we're looking for. Yeah, one of the kids died, but they weren't charged for it. Yes, that's true. So yeah, or at least they couldn't prove it. So either way, so yes. So all those things. So please go back to jail and please enjoy your prison for 140 months or 108 months as the case may be. And, maybe try to not be such complete horrible people when you get released eventually. It would be nice. That'd be great. So that brings us to the end of the discussion of this case. Thank you so much for tuning in to Uncivil Law. I do appreciate your time. Just a friendly reminder to hit that subscribe button if you haven't already, and I will see you next time, and bye-bye for now.